एंड ऑलवेज बच्चे की भी नहीं मारते है बहुत।
नहीं, नहीं, 7वें महीने के बाद से वो तो ठीक मारते हैं, एक मिनिमम कुछ 40 या 50 पीस मारता ही है। अगर नहीं मारा ठीक है, और लॉन्ग टाइम में अगर नहीं मार रहा है तब प्रॉब्लम नहीं। वो सब मारता है, वो सब तो आप फील कर सकते हो, वो सब रहता है। हम बोल रहे हैं ये जो कॉम्प्लिकेशंस, देखो दो तरह का कॉम्प्लिकेशन, एक ये सब जो केस है ये तो सडन आता है, एक जो कॉम्प्लिकेशन होता है वो एकदम स्टार्ट में आता है 1 to 3 मंथ से। एनवायरनमेंट अच्छा नहीं है कि आपका ये प्रॉब्लम है, किसी किसी का जैसे मिसकैरेज होता है कि 1 to 3 मंथ्स में ज्यादा रहता है, सबका प्रॉब्लम होता है। अरे 1 to 3 मंथ्स में ही
मेरा वाइफ का एक प्रॉब्लम ज्यादा हो जाता है।
प्रॉब्लम है, उसके लिए एक अलग से इंजेक्शन देना पड़ेगा, क्योंकि मेरा पॉजिटिव ब्लड ग्रुप है, उसका नहीं।
अरे ठीक है, वो मैनेजेबल है।
क्या होता है ना कि बच्चे का ब्लड ग्रुप क्या है किसी को नहीं पता, वो अगर नेगेटिव है तो मम्मी का जितना मतलब न्यूट्रिशन है वो मम्मी के थ्रू उसके पास जाएगा, लेकिन अगर वो पॉजिटिव हुआ तो नेगेटिव से पॉजिटिव मतलब न्यूट्रिशन सारा ट्रांसफर होने का चांसेस 50-50 रहता है, कभी होता भी है कभी नहीं भी होता है। तो डिजीज भी कुछ ट्रांसफर ना हो जाए उसके लिए एक इंजेक्शन देना होता है, वो मेरा शायद नेक्स्ट महीना नेक्स्ट मंथ में शायद तो थोड़ा मेच्योर होगा तब देगा ना, उसका पूरा बॉडी
Good evening, everyone.
Good evening, sir.
From NPTEL.
Good evening, sir.
Good evening. Good evening.
So good evening, sir. At 6:30, I will go YouTube live, sir.
Okay. Okay.
Yes, sir.
So they can watch from YouTube also.
Yes, sir.
Okay.
Sir, we are on live, sir. Please go ahead,
Okay,
sir.
sir. Yeah. Good evening, students. Please try to interact. Yeah. So this is the revisions monthly one session where we are going to give the overview of what we have discussed, and also a few queries were raised by the students. I'll try to answer those queries. If you are having any questions, you can raise the questions. Then we'll try to answer it. Okay. So till now we have completed 4 weeks. So in these 4 weeks, first week we have covered the history and evolution of insolvency law, where we have covered history from ancient to medieval. In the ancient, we have discussed about Satya Yuga to Kali Yuga, how in the Satya Yuga, the insolvency regime, do we have the insolvency regime or not? Then even we have discussed about the Maurya and Mughal period also, how debt relief was there, and what is the quasi systems, all these things we have discussed. So this is ancient period. Ancient period is Satya Yuga and Kali Yuga. And whereas medieval period, Maurya and during the Mughal period, we are having the debt recovery system. So those things also we have discussed. Then subsequently, we have discussed the colonial era, where we have discussed about the Indian Insolvency Law 1848, then Presidency Town Insolvency Act and Provincial Town Insolvency Act. Because the Indian Insolvency Act, the British government thought that it is not appropriate to, it is not sufficient to recover the debts to regulate, because in India we are having various customary practices. So that's why to recover the debt and to do the business appropriately, properly, they were having two legislations: Presidency Town Act and Provincial Towns Act. Okay, so 1909 and 1920. Then after the independence, we are having SICA Act, then RTD-BFI Act and SURFACE Act. So subsequently, all these legislations were consolidated. So that is how we are having IBC, Insolvency Bankruptcy Code. So let us try to have the overview of each and every concept. So I'll give the overview for maybe 20 to 30 minutes, not more than that. Then subsequently, I'll give few updates. Then I'll try to answer the questions that were raised. We are already having the queries with us. So a few queries. I'll try to answer these queries. Then subsequently, if any student is having any queries, they can raise the in between also. Feel free to ask the questions. Nothing wrong in that. So if you observe the colonial insolvency law, we are having Presidency Towns and Provincial Town Insolvency Act. So Section 9 of the Act deals with the transfer to defeat the creditors and who can file the petition under these legislations, debtor and creditor, where debtor is 500 plus rupees and creditor 500 plus rupees. For everyone, it is a 500 rupees only. Then we are also having provisions relating to protection and discharge. So if you observe the major provisions under the insolvency laws, there is Presidency Town Insolvency Act and Provincial Town Insolvency Act, Section 25 and Section 35 and Section 55. These three are major provisions. So Section 25 speaks about protection from the arrest, and Section 35 of the Act, discharge conditions. So that is when a person can be discharged from the insolvency. General presumption is that when someone files a petition, that is insolvency petition, I mean, he is not liable to pay any amount, but that is a misconception. So he is supposed to repay the money, and subsequently also he can earn the money. And if he is earning the money, he's supposed to pay the money. Then after paying entire debts, then only a person is considered to be discharged. So that's why under Section 35, we are having the conditions for discharge conditions. That is when a person can be discharged from the insolvency. That is under the Presidency Town and Provincial Town Insolvency Act. Then subsequently, the provisions relating to Insolvency Act the insolvency of the corporate sector were there under the Companies Act 1956. So if you observe Companies Act 1956, we are having two modes are there. Here I am talking about the companies only. So two modes are there where you can go for liquidation. So the liquidation can be done either under the tribunal, that is approval by the tribunal, and under the voluntary mode. So we are having the grounds are there. We used to have the grounds under the Companies Act 1956 under Section 433 of the Act. So where it is provided that inability to pay the debts, default in filing, just and equitable reasons, resolution by the company. So these four are major provisions or major grounds when a company can go for liquidation. So whenever, if any company is inability to pay, so that is if any company is unable to pay the debts. Here in the classes, we have discussed what is the meaning of inability to pay debts. Then if any company fails to file the returns, that is, we are having annual returns. Like every company is expected to file the annual returns every year compulsorily. AOC 4 NGT7 under the new act. Previously, it used to be INC 23A ACA. So it is nothing but annual returns and filing of financial statements. So if any company fails to file the financial statements, we are having conditions continuously for 3 years, then that can be a ground for liquidation of the company. And just an equitable, when the court feels that it is just an equitable to close the company, then also they can close the company. And if company, the members, they themselves, if they pass the resolution to close the company, that is liquidate the company, even that is also one of the reason, that is also one of the ground for liquidation of the company. So under the Companies Act 1956, we were having 4 clauses. Inability to, 4 grounds are there. Inability to pay the debts, then default in filing, just and equitable reasons, and resolution by the company. Then who can file a petition under these sections? Creditors, contributors, registrar, and the government also can file a petition under this section. Yeah, any doubt, sir? Any doubt, madam? Yeah. Then please remember, when the liquidation process is deemed to be in enforcement, when you file the resolution plan from the date of resolution plan. Tell me, madam, any doubt?
Black.
Are you talking with me?
ये मतलब पहला सिर्फ राइट हैंड का है,
Pardon?
ये भी सिर्फ राइट,
Please mute
तो
yourself,
वो
madam.
ये दो चलता कैसा भी लगाए तो क्या करना है, डिजाइन है ना वो।
Let me mute.
देखो कौन लगा, ये मैं लगाई मूवी का।
I'm muted. Yeah. Any queries, sir? Someone has raised some query. Yeah. I think I can share the screen also. Yeah. So then we were having the provisions relating to liquidation under the Companies Act 1956. Then we are also having the provisions relating to voluntary winding up of the company, where we are having members voluntary winding up, creditors voluntary winding up, and supervision winding up. So, is mute. Yeah. So under the members voluntary winding up, when you can go for members voluntary winding up, when the company is solvent, and you have to file the declaration of solvency. And once it is done, then once if you file a petition before the then CLB, right now NCLT, so then liquidator will be appointed by the company. So this is how we have discussed the provisions relating to voluntary winding up. Then under the creditors voluntary winding up, when the company is insolvent, please remember members voluntary winding up when the company is solvent. That means they were able to pay the debts. Okay, under the creditors voluntary winding up, the company is insolvent. So when the company is insolvent, then in such cases, creditors meet and they will appoint the liquidator. Then section 500 to 509 provisions were there. So under those sections, they used to deal with they used to proceed with the voluntary winding up of the company. Then we are also having the supervision winding up. That is under the supervision of the CLB. It is very rare cases. Court will interfere and they will go for winding up of the company. So that is how we have discussed the provisions relating to voluntary winding up. I think we have discussed that in session number 5. Okay. Then subsequently we have discussed few case laws before IBC. These are all the few important judgments the students may note down. Madan Lal versus Sri Chand Dio. So whenever there is a deadlock is there, so when you can go for liquidation. So whenever there is a deadlock is there, when the court feels that just an equitable, then they can go for winding up of the company. So in the case of Mohan Lal versus Grain Chambers. So statute, it is discussing about the statutory notice, and we have to prove that the company's inability to pay, because one of the ground for winding up of the company is when the company is inability to pay. So you have to prove that. Then after IBC, the shift to default test. So previously, when the company is an inability to pay, then you can file. Now, whenever there is a default is there. So in the case of Innovative versus ICICI, so already we have discussed in the classroom. So in this case law, it is clearly held that there is a shift is there from the default to the default. Then another important case law, Swiss Ribbons versus Union of India. So in this case law, it was held that wherever it is possible, the court will try to go for resolution, and the commercial wisdom is more and more important. So instead of going for liquidation of the company, we'll try to go for resolution. So that means we'll try to revive the company. And in K. Shashidhar versus IOB, so commercial wisdom is considered to be supreme. So if you observe the change, previously the one of the solution or the solution generally the court will insist is in liquidation of the company. But whereas after IBC, default is to be proved. Then instead of going for liquidation, we'll go for resolution. Why? Because one of the main aim of IBC is not to close the company. It is to revive the company. So through the resolution process, they will go for reviving the company. And in subsequent classes, we have discussed about the UK and USA. In UK, we were having the legislations like Insolvency Act 1986, then Enterprise Act 2002, and we have discussed about the CVA, administration, restructuring plan. So all these things we have discussed. In US, if you observe, we are having Title 11, that is also called as Title 11, Bankruptcy Code, and Chapter 7 is there, Chapter 11 is there. Chapter 15 is also there, but among these three things, Chapter 11 is very, very important. In the subsequent lessons, okay, because it's only 1 month is completed. So in the subsequent lessons, you will understand, if you read the Chapter 11, then if you compare our IBC lessons, then you will understand the importance of Chapter 11. Then debtor in possession. So that is one of the unique nature of the US law. So whereas in India, we are following creditor in possession under IBC. We are following creditor in possession, whereas in US they were following debtor in possession. So that is one of the major difference between US and India. Then subsequently, subsequent lessons we have discussed about various committee reports and SICA evaluation to IBC. So how various committees gave the report. So as a part of which we have discussed Tiwari Committee, Narasimhan Committee, Justice Eradi Committee, JJ Irani Committee, and BLRC. So BLRC is considered to be one of the important, and you have to read BLRC committee report. Okay, and that's very, very important, even subsequently also. Then Insolvency Law Committee, ILC. Then subsequently we have discussed SICA overview. Then we have discussed the introduction to IBC. So till here we have discussed, I think in first four. So what we have discussed in Tiwari Committee, so it is the basis for SICA Industrial Companies Act 1985. So why Tiwari Committee was established? Because the industrial sickness was increasing, and there is no time-bound revival. So that's why Tiwari Committee recommended we should have a specific legislation. So that's why SICA came into picture. Then the key recommendations of Tiwari Committee includes identify the sickness as early as possible so that we can revive the company. And Tiwari Committee recommended to set up the BAFR and AAIFR. So BAFR, AAIFR, there is these are all quasi-judicial bodies. And one of the students asked one question by looking at the slide is that in one of the case law, I didn't remember exactly the case law. So, but in one of the case law, Supreme Court pointed out that BAFR decision is supreme. Then does it mean that he cannot go to AAIFR? No, it is appellate tribunal. So Supreme Court mean to say that when BAFR, in case of SIC companies, BAFR is having the jurisdiction. So other courts, like previously we have High Court and other courts also used to deal with the company cases. So other courts, in case of SIC companies, other courts, they don't have the jurisdiction. So once a company is considered to be SIC company, so to deal with the SIC companies, BAFR is having the jurisdiction. So they are having the supreme power. You can go for an appeal before AAFR, that is possible. Okay. So this is one of the questions raised by one of the students. Then we have discussed about revival for viable units. So wherever there is a possibility, we have to revive the units, and non-viable ones we have to liquidate. So BAFR was established to verify is there any possibility of reviving. So they will divide into units, and if any unit can be revived, they will revive it. Otherwise, they will liquidate it. Okay. And the key recommendation is promoting the financial coordinated. So accordingly, based on the recommendations given by the Tiwari Committee, we are having SICA Act, but it is not so successful. Then subsequently, we are having other committee, Narasimhan Committee, 1991, Narasimhan Committee to 1998. So 1991 recommendations, if you see, they were defining NPS, and they were talking about the capital adequacy and autonomy to the banks. So they recommended that we need to have the autonomy to the banks and reduce directed credit. So accordingly, now we are having RT BBT Act. There is another legislation, recovery of the debts. Then in 1998, Narasimhan Committee 2 was there. So accordingly, they gave the recommendations, strengthening the DRTs. So it recommended for the strengthening the DRTs, and they enabled the ARCs. So accordingly, SURFACE Act came into picture. So under the SURFACE Act, I can say banking institutions, all financial institutions are having powers to recover the money, and they can attach any property. Then they recommended push for bank consolidation and better governance. So these are all the various recommendations given by the Narasimhan Committee. Then in 2005, we are having another committee, J.J. Irani Committee. So J.J. Irani Committee is not totally concentrating on the liquidation, but it is concentrating on the modernization of the company law. So if you observe the key highlights, fast-track mergers and acquisitions for small companies, they recommended. Then they recommended time-bound insolvency resolution, but that was not realized under the Companies Act 1956. Then they strongly supported the NCLT. So in 2005 only, actually they supported NCLT, but we were unable to establish. Though in 2013, that is Companies Act 2013, we were having the provisions for NCLT creation, but till 2017, I can say it is not so effective. Then professionalize the insolvency process. They recommended for the professionalization of insolvency process. Then they recommended creditor in control. So in US, we are having debtor in control, whereas in India, we recommended, J.J. Irani Committee recommended creditor in control. So they laid down foundations for 2013 legislation. Then before 2013, actually, we are having Companies Bill 2008 also. So actually, based on the J.J. Irani Committee report, we are having Company Bill 2018. We were unable to pass it. Subsequently, 2013, we were able to pass the 2013 Act, Companies Act. Then, subsequently, we are having BLRC. This is another important committee. So they have developed the core philosophy. So whatever we are having IBC code, the core philosophy is developed from the BLRC committee only. This BLRC committee recommended time-bound resolution process, 180 plus 90 days. We have discussed in detail. And creditor in control, not debtor. And unified the law for all entities, companies, LLPs, and individuals. But reality is that though IBC is having provisions for companies, LLPs, and individuals, the provisions relating to individuals and partnership firms, they are not yet notified. Please remember. Okay, so they are not yet notified. Right now, only companies and LLPs were regulated. And if any individual who gave guarantee to the corporate, that is corporate debtor, then in such cases, personal guarantors are included. Otherwise, generally, they don't come under the individuals. They don't come under the purview of the IBC as of right now. Then they have given clear waterfall mechanism under section 53. In subsequent lessons, you are going to discuss about the waterfall mechanism. Before in the liquidation process, you are going to discuss about the waterfall mechanisms. Then BLRC committee, even they recommended for IBBA as a regulator. So they recommended that we should have a regulatory authority. There is nothing but IBBA. So based on the recommendations given by the BLRC committee, now we are having IBBA. So in subsequent lessons, we are going to discuss what is IBBA, how they are going to function. So what are all the powers of IBBA? So there is one separate lesson is there for IBBA. So you are going to discuss about the IBBA in the subsequent lessons. Then we have.
Sir,
Yeah,
I
tell me,
had
sir.
a question. Sir, you said that the for the individuals it's not yet notified, but in the applicability there's a separate category, individuals other than personal guarantors. So what is that meant to include then?
Yeah, suppose take the example, madam. I'm an individual. I took loan from you. You are also an individual. I am also an individual. So in this case, we are not regulated by IBC. IBC is not applicable in our case. Suppose I'm an individual. I gave, suppose imagine one company took loan from the bank. I gave guarantee to the bank. In such cases, I'm considered to be personal guarantor. Then IBC is applicable.
So, sir, the category that they've made for individuals is not yet notified,
It
right?
is not
As
yet.
in, like,
It is not
okay.
yet notified.
So they've just
Individuals,
made the category, but it's not yet regulated by IBC.
yeah. So individuals, the provisions for individuals and partnership firms, they are not yet notified. So IBC provisions are not applicable to individuals. That means if any individual defaulted, IBC provisions are not applicable. If any individual or partnership form. So when IBC provisions are applicable, if any company or if any LLP, if they default, then IBC provisions are applicable. Only one exception is that suppose I am an individual who gave guarantee in favor of the company or LLP. Then in such cases, they can take the action against me under IBC.
Got it, sir. Thank you.
Yeah. Thank you, madam, for asking the questions. Otherwise, it's like talking with the wall. Anyway, so then subsequently, we are having the Insolvency Law Committee, ILC 2018-2012. So this is after IBC actually. So after IBC came into picture, there are so many cases are there. Actually, it is evolving subject. I can say still it is evolving subject. We have crystallized so many provisions, but still it is evolving subject. Even if you observe recent Bhushan Steel case, and again yesterday there was a hearing was there before I mean, we are expecting some more updates, okay, relating to Bhushan Steel. So still it is evolving subject actually. So 2016 we are having the legislation. Then subsequently the government thought we should review the legislation. So accordingly we are having ILC. It's a regular process actually. So ILC committee is there. The ILC committee 2018-2012, they made certain recommendations. So the major reports post IBC, if you observe, the major reports includes 2018. They have included home buyers under the financial creditor category. So previously, home buyers, they were not considered to be financial creditors, but now from 2018 onwards, they are considered to be financial creditors. So this another one of the important major change that happened in 2018. Then 2018, they were also they gave reports about cross-border insolvency also. It is based on unilateral model law. Then 2020, group insolvency pre-pack for MSME, pre-pack PPIRP, pre-pack insolvency IRP, insolvency resolution process. So PPIRP is also introduced 2020 for MSME specifically. Is it effective or not? In the subsequent lessons, we are going to discuss actually. So PPIRP for MSME, everything we are going to discuss. Then 2021, we were having certain amendments, ease of liquidation. So the liquidation process, they have liberalized liquidation process. So those concepts you are going to discuss in the month of third month actually. So where Pawan Kumar sir is going to discuss in detail. Then subsequently again we can have one more live session if any doubts are there. Then 2022 fast track admissions, EDR joint COC is also in. These are all the major reports after the IBC. So 2018 we are having some amendments. 2020, 2021, 2022. So the basic, I mean, the major aim of this Insolvency Law Committee is update the legislation from time to time. As and when it is required, update the legislation. So accordingly, now IBC is enhanced, I can say. So these are all the various things that we have discussed. Then we have discussed about the SICA 1985. If you observe the key takeaways, why it failed actually, it is data friendly actually. So, and long delays. So we expected that SICA is going to solve the problem of SIC industry, but it was not happened actually. Okay. So long delays were there and they used to take 8 years, 9 years, 6 years. So long delays were there. So no creditor is having the control. So once the SIC industry is there, then the existing board of directors only they used to manage the company. So that is a problematic. Then misuse to avoid the liquidation. So instead of liquidating, so once if you declare any company as a SIC industry, then it will go on. So till that time, the board of directors can enjoy the fruits or the promoters can enjoy the fruits. So that is why this system was failure. Okay. If you observe the key provisions of SICA, section 15, reference to BAFR, when to refer the matter. Section 17 and 18, revival schemes, how they are going to have the revival scheme. We are having one lecture is there on this. Section 22, already it is completed. Section 22, suspension of proceedings, when the proceedings can be suspended. So section 15, 17, 18, 22. So these are all the important provisions. And please remember, now SICA is repealed, IBC took over the proceedings right now. Then subsequently, we have discussed the quick introduction to IBC. I don't think so. We have started the concept of moratorium, then subsequent concepts. So IBC, subsequently, we have discussed IBC, quick introduction. So please remember, it is not just another law. Please remember, it's not only single legislation. So insolvency law is going to consider the financial state of the company, and it is a consolidation of various legislations. You have to understand it's a consolidation of various legislations. And in this lesson, we have discussed what is insolvency, what is bankruptcy, and the difference between, I think I have explained you in detail. If you observe the videos, you will understand. I have explained you in detail what is the insolvency, what is bankruptcy. So insolvency is a financial status. So that means if I am unable to pay, if my pocket doesn't support, then that is called as insolvency. Someone goes to the court of law, and if someone declares me that I'm unable to pay, that is legal status. That is bankruptcy. So what are the major goals of IBC? So maximization of the asset value is one of the major goals, and promoting the entrepreneurship is another major goal. Why? Because if already under the Companies Act 2013, the entry process is very easy. That means if you want to start any company, the entry process is very easy right now. So within 7 days, 8 days, you can incorporate the company. Okay. So previously, we used to have name application. Again, after getting the name application, prepare MOA, AOA, then submit it to ROC. It used to take a lot of time. But now also, more or less, procedure is similar, but everything is digitalized, I can say. So everything is online. So now, under the Companies Act 2013, you can just file SPICE Plus, that is Part A. SPICE means simplified pro forma for incorporation of the company electronically. So SPICE Plus, Part A. So once if you file, then within 1 or 2 days, you will get the name availability. Then you can file Part B. Then CRC is going to verify. Then they are going to approve the name, approve the company. Then they are going to give the certificate of incorporation. So if you observe previously under the old regime, incorporation process used to take 10 to 20 days, 20 days minimum. But right now, it is taking 4 to 7 days maximum working days, so 4 to 7 working days. This is one of the major change that happened under the Companies Act. But I'm entering into the business, but how to close the business? Suppose my business is not successful. How to close the business? So even exiting from the business must be very easy and it should be smooth. So that's why that is one of the goal of IBC. So if you do that, entrepreneurs, whoever is having innovative ideas, they may start the business. If they fail, then they can exit the company. So this is one of the major goal of IBC, and increasing the credit flow. So if creditors are having a security or assurance that if the promoter or if the company fails to pay the money, then there is a mechanism is there where you can recover the money and where you can realize assets and you can get the maximum value from the assets. If you are having that tendency or if you're having that legislative framework, then even banks can also assure, or banks can peacefully, they can give loan to any company. So this is another major reason, another major goal. And replace the debtor-friendly laws. So previously the legislations used to be debtor-friendly. Now it is creditor-friendly. Okay. So it is applicable to IBC, is applicable to all companies, LLPs, individuals, and guarantors. Now individuals, they are not yet regulated. It is not yet notified. Please try to understand. Then subsequently, we have discussed various important definitions, what is when IBC is applicable, and key definitions under section 3 and 5. I'm not going to repeat it once again. Key important definitions, then how to initiate the CRP process, what is the basic difference between financial creditor and operational debtors, key judicial decisions we have discussed. Then we have discussed about the background and objectives of the IBC. Then we have discussed the structure. What is the structure of the IBC? So if you observe the structure of IBC, we are having 5 parts are there. Part 1, preliminary. Part 2, corporate insolvency, which is already notified. Part 3, firms and individuals, which is not yet notified. And Part 4, insolvency professionals. And Part 5, miscellaneous provisions. These are all already notified. Okay. Then Section 2 of the Act, that is very, very important section. maybe you can highlight the section to whom IBC is applicable. IBC is applicable to companies, LLPs, personal guarantors, partnership firms, proprietorship firms, individuals. So first two categories are notified. Remaining two categories are not yet notified. You have to remember that. Then we have discussed the key definitions, like what is the meaning of debt, financial debt, operational debt, then corporate debtor, creditor, then insolvency commencement date, when it is considered to be commencing. So all these things we have discussed. Then subsequent to the definitions part, we have discussed about who can initiate the CRB. So you have to remember this. Under section 6, CRB process can be initiated in three ways. One is financial creditor can initiate, then operational creditor and corporate creditor. So section 7 speaks about the financial creditor, how they can make an application. So they can make an application either singly or jointly. And if the default amount is more than 1 crore rupees, then they can make an application. And we have also discussed about the forms to be filed, other things also. Then section 8. So then section 1 minute. Then section 8 and 9 speaks about the operational creditor, how they can make an application. Section 10. So these are very, very important sections. Section 6, who can initiate. Section 7, how financial creditor can initiate. Section 8 and 9, operational creditor. Section 10, corporate debtor. So we have discussed about the procedure also in the classes. Then we have discussed about the financial debt and operational debt. What is the basic difference between financial debt and operational debt? In a simple language, I can say financial debt means when I am taking any loan from the bank, okay, where the money is used for running the business. I may not take it as a loan, but where the money is used for running the business. So this is one of the reason, one of the basic logic why the court has held that the home buyers are also considered to be financial creditors. Okay, so you have to understand the logic behind it. When any real estate company is running the business, generally they don't invest the total amount. First, they will, the tendency is that big projects, they will collect the money from the home buyers. This money is used for construction. Then subsequently, once the construction is completed, they will allot the homes to the home buyers. So that's why these people, okay, so though traditionally they're not giving any loan to the real estate company, but because of their money only, real estate companies were able to run actually. So that's why the court has interpreted that because their money is involved in the operations and it is used as a capital, and there are few important judgments are there. I have given the few important judgments also in the lectures. So please read the judgments once again. Accordingly, the Supreme Court held that the home buyers are considered to be financial creditors. So it is one of the landmark judgment where how the IBC operates, it has changed a lot. Then what is financial debt? It is a time value of the money. Sudhakar sir, tell me sir.
Sir, good evening, sir. I joined a little late. Can you please put the slides in the PPT mode, sir? Kindly.
Yeah.
Thank you, sir.
I have one question.
Tell me, madam.
Sir, when operational creditors considered as in a financial creditors?
Generally, operational creditors are not considered as financial creditors, but home buyers, previously we used to consider them as operational creditors. Operational creditor means any person who supplies or who supplies goods or renders services to the company. They are considered to be operational creditor. But in case of home buyers, the Supreme Court has given the judgment stating that they should be considered as financial creditor. Is it clear, madam? So there are two categories, operational creditors and financial creditors. But in case of home buyers, though it looks like operational creditor because they are availing the services, they are purchasing the goods, they are availing the services from the company. Generally, they should, by definition, they should be considered as operational creditor. But the Supreme Court held that they are considered as financial creditors. Is it clear, madam?
Yes, sir. Thank you very much, sir.
Then we have discussed about the operational debt. What is considered to be operational debt? So whenever you are purchasing or selling, so whenever you are selling the goods or services, including the employment, and even your statutory dues, etc., everything is considered to be operational debt. So we have discussed in detail about the financial debt and operational debt in detail. I think half an hour classes will be there. So if you observe, there are few important cases are there in the operational debt. New Oka versus Sonbhadra. 1 minute, I'm unable to see. Yeah. Consolidated Construction versus Hitro, and Jaipur Trade versus Metro. So these are all important judgments under this chapter. So I'll give the slides to you. You can read it once again. These are all the important judgments, and these judgments were in detail. They were explained in the classes. Then subsequently, yeah, tell me. Realme C15. Any doubt? Then subsequently, yeah, we have discussed various judgments. Actually, my sessions, majority of the cases I have, it's like I'm going on discussing various judgments, how to support my argument, how the court has interpreted under different scenarios. Okay, so these are all the important judgments. If you observe, innovative versus ICICI is one of the important judgment. Pioneer Urban versus Union of India, where real estate allottees are considered to be FCs, and Vidarbha versus Axis Bank. And in this case, it was held that NCLT has a discretionary power whether to admit the application or not. And Manish Kumar versus Union of India. So class action safeguards for home buyers. So these are all the important judgments what we have discussed till now. And apart from this, I mean, whatever we have discussed, I just wanted to give few updates to you. So if you look at the updates, yeah. So if you look at few updates, one point that you have to observe is Indian Insolvency Act 1848 is first enacted legislation to address the problem of insolvency in India. So, which contains a distinction between treatment between the traders and non-traders. So this is not explained in the PPTs. So you may note down, and I'll give these things also to you through the groups. So Indian Insolvency Act 1848 is first legislation. This is already there in the PPT, but it is not highlighted. What is not highlighted is it contains the distinction between treatment of traders and non-traders. So you may note down this part. And Presidency Town Insolvency Act and Provincial Towns Insolvency Act, they were remained ineffective. And please remember, until and unless they were repealed, because till now it is, as already I told you, the law relating to individual insolvency is not yet notified under the IBC. So even today also, the Presidency Town Insolvency Act and Provincial Towns Insolvency Act, they are in enforcement. You have to remember this one. Then, sir, please, if you are having any doubts, you can unmute and ask the questions. Otherwise, please mute yourselves. Yeah. And another, I'll come to your questions, madam.
Sir, can you please repeat the legislation you mentioned where the difference between creditors and non-creditors is mentioned?
No. Traders and non-traders.
Oh, traders and non-traders.
Traders and non-traders. Under Indian Insolvency Act 1848, it is there in the slides also, but I have not mentioned that this legislation also contains a distinction between traders and non-traders. They have made a distinction. Okay, madam?
Yes, sir. Thank you.
Yeah. Chart box I will see later. I'll try to answer each and everything subsequently. Okay. Then Precedents on Insolvency Act and Provincial Town Insolvency Act, they are still in enforcement until IBC code repeals it. They are in enforcement. So till now, IBC code they have not repealed. Okay, so as already told you, the provisions relating to individual and partnership forms, they are not yet notified. So if they are notified, then this Presidential on Insolvency Act and Provincial Town Insolvency Act will be repealed. So this you have to observe. Then another important point that I just wanted to note down is you may read more about Swiss Robinson case law and K. Shashidhar and Innoventive. These three case laws. You may read, I mean, these are all explained subsequently, but you may read separately.
Sir, can you just repeat the case name?
Swiss Robinson. I'm just posting it in the chat box. Swiss Robinson, K. Shashidhar, and Innoventive Industries. Please try to read these three judgments. We'll try to circulate the material also. If it is
request the material because I'm listening you with I'm driving at present. I'm not able to. I'm not able to, sir, copy the link, whatever you shared with us. So please share the material, sir, on email or through.
I think we are in groups, madam. So my TAs, Sharada.
Yes, sir.
Yeah, can we share the text material?
Yes, sir. Once the session is over, everything can be shared in the discussion platform, sir.
Okay. So what we'll do is we'll prepare the gist of Swiss Robinson case, Shashidhar and Innoventive Industries. Then we can share it.
Yes, sir.
Okay. And someone is raising, I'm not in the group. Yeah. So
Sharada, it is not a group per se, sir. It is just a discussion platform in which everyone who is enrolled to course will have access to. Okay. So they just have to open that discussion platform and then view the discussion, sir.
Yeah. Is it clear, Mira?
Because
sir,
all the announcements.
Sir?
Yeah.
May I add something, sir?
Yes, sir. Sudhakar, sir, tell me.
Sir, it is a discussion platform on the course website itself, sir. It's
Okay.
a separate platform.
So I think who was this question? Some doctor is there. Pratima Soni, is it Dr. Pratima Soni?
Yes, sir. Yes, sir.
Okay, so my TS will share the material, madam, in the group platform itself. You can have the access.
Okay, sir.
Okay.
Thank you very much, sir.
Yeah, thank you, madam. It's our duty. Then another important point that I just wanted to highlight is previously under the SICA, we used to have BIFR. Now all the cases under the BIFR, they were transferred to NCLT. Maybe it is not there in the slides. Just please, you can note them. Okay, so the functions of NCLT were under the IBC, and post repeal of the SICA, automatically all the functions were transferred to NCLT. So now we don't have BIFR. All the cases which were there before the BIFR, they are all transferred to the NCLT. So this point you may note down. Then you can read more on the why SICA failed actually. So one of the reasons, I think already I have explained you in the slides itself. One of the reasons why SICA failed is there is no time framework actually. So it used to go on for a longer period. So this is one of the reasons why SICA failed. I just wanted to highlight. And in ERADI committee, this you may note down. ERADI committee, they recommended the repeal of SICA. And they recommended the establishment of NCLT. This is another update I just wanted to update. RRD committee, they recommended the repeal of SICA and they recommended the establishment of NCLT. Then, yeah, so if you observe the applicability of the code, so as already I have explained you, the provisions relating to except the personal guarantors, the provisions relating to individuals and partnership firm, they are not yet notified. I have highlighted in the slides in different color. I have explained you, but it is not exclusively given in the slides. Okay, you may observe that is highlighted and that is also explained. Then, if you observe maybe 12th session, as already we have discussed, the home buyers are considered to be allottees and home allottees. They are considered to be financial creditor. For this, you can refer Chitra Sharma versus Union of India, Chitra Sharma versus Union of India, and Pioneer Urban Land Infrastructure versus Union of India. I'm just pasting it in the chat box also. So you can read these two cases. We'll give in the group discussion only, we'll give the overview of these two cases. These two cases you can observe. Then, another important point that you may observe is, we have discussed about IUs. Maybe subsequent lessons you are going to discuss more about IUs, information utilities. At present, we are having only one information utility right now, which is working is NESL. Okay, then for the practical reasons, whenever you are initiating the CERP, okay, you are expected to attach a Form D, which is issued by NECL to be attached whenever you are initiating the CERP. I'm just texting it, the same thing in the chat box. So right now we are having NESL, only one information utility, NESL. So whenever you are making an application for initiation of CERP process, Form D is issued by the NESL. You have to attach the Form D. This is practical. If you are practicing, then this is useful. Okay. Another clarification. When I was explaining about the Vidarbha case law, the Vidarbha case law, subsequently, the same Supreme Court has subsequently wide order in the case of M. Suresh Kumar Reddy versus Canara Bank others. So they have changed the decision. So you may note on this, and we are going to share it in the group itself. How Supreme Court has given in Vidarbha case law, what was the change in the Suresh Kumar case law. Sharda, you may note on this. Then we can circulate it. Okay, so these are all the various updates that I just wanted to give. Then let me look at the chat box.
Sorry, sir. Sir, just now you have said that a Supreme Court in Vidarbha case has overruled the Suresh Kumar Reddy case.
No. Suresh Kumar Reddy case overruled the Vidarbha.
Oh.
There is a change. There is a difference there between these two cases. We'll give the material on this. What was there in Vidarbha? What is there in Suresh Kumar?
Okay.
And one more query which is raised by the participant is that, just let me open it.
Sir, should I read out the query for you in the chat box?
No, I'm reading it. No issues. How IBC replace other laws for insolvency and bankruptcy? What about CRP? It's creating confusion in process and solution. What is your opinion? Please remember, IBC is a legislation which is consolidating all the legislation that we are having right now. So it is not totally replacing. I can say it is not totally replacing. It is not totally replacing. It is the legislation which is consolidating. Suppose if you take the example of SIC industry, SICA Act. Now it is repealed actually. Okay. So how IBC is replacing? So IBC is replacing SICA. And now previously under SICA, we used to have the concept of SIC industry and BAFR used to deal with the cases. Now under IBC, the concept of total SIC industries companies is totally eliminated, that is repealed. Now it is covered under the CRP. So under SICA, we are having the concept of SIC companies. Under IBC, now it is totally dealt under the CRP process. If you observe Surface Act, even Surface Act is also, though it is not repealed, but to some extent IBC replaced. Okay, so why? Because under the Surface Act also, the secure creditors, they can recover the money under the Surface Act by using the Surface Act. So even under IBC also.
Sir, you're not audible.
Now, am I audible?
No, sir, you're very much audible. I think so. The participant must have some network issue.
Okay. So please verify your network, madam. Anyway, so under the IBC, even under IBC also, the secure creditor is giving the they have given the importance to secure creditor. So that's how it is complementary to each other. It is not replacing, it is complementary to each other. That is Surface Act and IBC. Then if you observe Companies Act 1956, we are having provisions from section 271 to 273. We have provisions relating to winding up. Now these provisions were not there. So the corporate insolvency and liquidation procedures are there under IBC. So totally Companies Act 1956 is repealed. Now we are having provisions under the IBC. Then if you observe the recovery of the debts due to banks and financial institutions, there is another legislation. So the basic objective of this legislation, it is also called as RDD-BFI legislation, debt recovery by the banks. So the basic purpose of this legislation is debt recovery. If you observe RDD-BFI, compared with that, IBC is most preferred. Why? Because IBC offer faster and more structured resolution. So instead of only recovering the debt, only exercising the rights over the assets, under IBC, you can directly go for CRP. If you are going for CRP, entire assets will be considered. Not only secured assets, the entire assets are also considered. So that is one of the major difference, how it is replacing. And Provincial Insolvency Act and Presidential Insolvency Act, as already I told that, once Part 3 is notified, then IBC is going to replace. But as of right now, it is not yet replaced. Then we are also having Companies Second Amendment Act 2002, where they recommended NCLT, but we were unable to realize it. But under the IBC, now NCLT, NCLAT are operational. So these are all the major changes that happened. And that is how IBC replaced. It's not replaced. Sometimes it is complementing. Sometimes it is replacing. So if you take the example of SICA, it is the replacement. Surface Act, it is complementary. Companies Act 1956, totally replacing. And RDD-BFI legislation, it is complementary in nature. This legislation, that is IBC, is complementary in nature. And provincial and presidency terms, it is going to replace. If it is notified, IBC is going to replace. So this is how IBC is replacing. Sometimes it is replacing. Sometimes it is complementing various legislations. Is it clear?
So there is one question that I would like to ask, sir.
Yeah, yeah.
So you told that Sika was in favor of debtor, and that is why it was replaced by IBC. And then now IBC, I think, because now in one of our current cases, the borrower is a personal guarantor, and he has filed application according to Section 95 to invoke in interim moratorium. And then he is trying to stop the SARFAESI action of taking physical possession or recovery of debt by sale. After triggering interim moratorium, the borrower continuously tries to withdraw the application and then refile it. This cycle continues again and again. So what will our solution be to stop this cycle, because this is a total abuse of the process of law? So what is your take on this, sir?
You mean to say that Section 96 of IBC only, no?
Yes, sir.
Okay. So he's using the moratorium right now.
Yes.
Okay. Then this is one of the lacuna. I am not denying it. Now everyone is using, so many people are using this. But from the creditor's point of view, we can speed up the process at COC. There are instances where to avoid the SARFAESI Act, the creditors, the corporate debtors were using to file the using the IBC. It is happening actually, but we have to we can have control over the COC if you are a creditor.
COC meaning, sir?
Committee of the creditors. If you are a creditor, you are a part of COC. You will be a part of COC, committee of the creditors, under the CRP process.
Okay.
So then you can have the control and you can speed up there.
Sir, I am not getting where you're trying to tell us to speed up.
COC, madam, in COC, committee of the creditors, you can speed up the CRP process.
CRP process. Sir, here we are not the applicants, and guarantor is the applicant. I mean, the borrowers are the applicants. We are not applying for, insolvency process. Because we want to recover by selling their assets, a mortgage to us.
Okay.
So what is the way out, sir? Because they are trying to invoke the interim moratorium again and again by filing the application, because according to Section 95, it says that once the application is filed, the interim moratorium starts.
Section 14.
Yes. No, that is Section 14 is for corporate debtors, but Section 95 is
okay,
for
you are talking about personal guarantor.
Yes, personal guarantors.
Okay, okay.
So interim moratorium starts automatically. But Section 14, at least we have the time gap until the tribunal says moratorium applies. But in this case, once the application is filed, the moratorium starts.
Yes, madam, you are right.
So we are not able to take physical possession or recover by sale, because we are not supposed to take any action.
Okay. I understand.
During that
I
time.
understand. Immediately, I cannot give the answer, but definitely I'll post it, the answer, maybe within 1 or 2 days.
Thank you, sir. Please.
In the group itself.
Okay, sir.
Sharada.
Yes, sir. I have taken.
Yeah, please
Yes,
note
sir.
on this.
Yes, sir.
In case of personal guarantor, if he is invoking or if he is filing application under Section 95.
Yes, sir.
We'll try to answer. Okay.
For
Yes.
one case, that AR Babu versus SBI, in that there was a judgment like that, that during moratorium time, SARFAESI can be proceeded. I think I have read it there.
Okay, but can you sell? Can you sell the property?
No, we cannot. I have to check that once again. That
You
is
can,
AR Babu.
You can attach.
AR Babu versus SBI.
Okay.
Dr. Abdul, that is ERA construction, it was in NCLT.
Okay, okay.
And also, if he's delaying, they can file that fraud inquiry like that under PMLA Act violation. I mean, you can do it.
But PMLA is criminal, sir.
Sir, I mean that is a. I mean, they have taken loan and they are not repaying it. In some cases, they will file to CBI. If it is some, I have seen some cases.
Sir, when any criminal proceedings are there, the protection under IBC is not applicable. So you can proceed. So Priyanka madam, she is talking about the possession. So it's a civil matter. So for civil matter, moratorium is applicable. Whereas for criminal matters, so this IBC cannot give the protection. So you can proceed with the criminal matters. But anyway, so will verify, sir, once again. Can you please refer the case law once again for our record?
Okay, I will type in the chat box.
Okay, sir. AR
Sir,
Babu was.
I had a question.
1 minute, madam.
Yes, sir.
Sarada, please note down the case law. Then we'll do further research and we'll get back to them accordingly.
Yes, sir.
Yeah, madam, tell me, madam.
Sir, in the definition of claim, you had said that right to remedy should be giving rise to right to payment. So whether the two clauses, the semicolon that is used is to be interpreted as and or. So what I mean to ask is whether just right to payment is enough, or there should be necessarily be right to remedy as well.
See the section, then I can get it.
Yes, sir.
You are talking about which section, madam?
So just give me a minute. It's related to claim. It was section 3(7), I believe.
Okay. Let me open the act.
Yes.
Yeah. So you are talking about claim definition. Yeah.
Yes.
Can you please tell me where you are asking? Claim means
So
a
the
right to payment.
semicolon that is used in between the two clauses, whether that is to be interpreted as and or, and by that I mean to ask whether right to payment is enough, or there should necessarily be right to remedy as well.
No, it is R only.
It's or, okay.
It's R only.
Okay.
You are talking about interpretation between clause A and clause B.
Yes, sir. Yes.
It is R only. It is not and.
Okay. Okay, sir.
Okay. Any other question? Sridhar, sir.
Sir, can we get the recording of this session, sir? I joined late.
I think we can get, sir, and it is live streaming.
Okay.
It will be there in the YouTube, sir.
Yeah. YouTube.
Okay. Thank you so much.
Yeah, thank you.
And thank you so much, sir. I mean, your lessons have been very, very lucid and very, very interesting. And
thank you, sir. It's only introduction to IBC, sir, actually. So we can dwell a lot, actually.
So when will be your next session, sir?
Live session.
Live session, sir.
Next month again we'll have, sir.
Okay. So once
mostly every month we'll have the live session. Okay. Last month again you may have live session by one of the practicing professional. Along with him, even I will be there.
Okay. So I am also preparing for the LIE, sir. So probably I'll take maybe 45 days or so.
It takes time.
Before this exam starts, I should be taking my LIE.
Yes. It takes time, sir. You have to prepare the regulations thoroughly.
Yes, sir.
So regulations matter a lot.
Yes, sir.
Okay.
Thank you so much, sir.
Thank you, sir. Any other questions? If no other questions, we have noted down the other questions. Sharda?
Sir?
Yeah, please note down the questions that is raised by Priyanka.
Yes, sir. Yes, sir. I noted down the question.
We'll try to give the answer maybe within tomorrow or after tomorrow in the group itself.
So can you verify with Priyanka ma'am if she has joined the group so that the answer will be visible only in the group, the discussion platform?
Priyanka madam, are you there in the group?
Yes, I just saw the group. Discussion forum.
So,
yes.
We'll post it, madam. As early as possible, we'll post it.
Thank you, sir.
Because even we had to verify with our law firm also.
Okay, sir.
We had to do some research, then we'll get back.
Thank you, sir. Thank you.
Any questions? Yeah. Shall we wind up then?
Yes, sir. No, sir. Thank you. Thank you so much.
Thank you very much. Thank you very much.
Thank you. Thank you,
Thanks
sir.
to your team also, sir.
Yeah.
Thank you, sir.
Thank you. Thank you, sir.
Thank you.
Thank you. Thank you, everyone.
Thank you, everyone.
Thank you, sir.